And welcome back. If you're joining us, we're going to be venturing into a discussion this morning that is two parts. We have with us on set Attorney at Law, Audrey Matura, and we are going to be discussing the Referendum Act. As we mentioned prior to the commercial break, we want to be able to get a complete understanding of this particular writ and, of course, what it means and the bearing that it has on what is presently taking place before the courts. Good morning, Audrey.
Good morning. Thanks for having me.
Thank you for being here.
So, clarification, I'm not attorney for any of the groups.
Yes.
Yeah.
And
yes.
I'm not with any group. I'm just...
You're helping us to break down the law into layman terms, and also helping us to put into context exactly what is happening before the courts. And I also, as I said in my introduction, you have had a substantial amount of interaction with the Referendum Act, because we can recall over a decade ago where you had attempted to get a referendum held on the offshore drilling issue.
Yes.
Yeah.
So we can start with saying there are four things in law.
Yeah.
Or four ways you can have a referendum. One, and that's in the Referendum Act, is that there's a resolution in the National Assembly that we want a referendum on a particular issue. So government could say, you know what, I want a referendum on whether or not we should absolutely remove from our constitution the death penalty. Because technically it's removed, but it's not officially removed, right?
Yeah.
They can take that on their own. That's one way. The second way is the way that I tried through Oceana, where we went to seek petition of people to say, this is a national issue. We need at least 10% of the voting population to sign a petition. And once that is signed, we send it to the Governor General. They vet it. Once we reach the provision, then there can be a referendum. Well, we know that was not successful, yes. Yeah. So the third way is where a law provides that there must be a referendum. So let's say there's a law on livestock, and they want to decide whether we should continue having slaughterhouses inspectors, and you want a referendum on that issue. It might be a local issue, but maybe the law says there must be a referendum.
Or like constitutional changes.
Yes, the constitutional changes too. And then the final one is on any proposed settlement with the Republic of Guatemala for resolving the Belize Guatemala border dispute. And this is the controversial one, because when you read a legislation, you give it its basic meaning, the meaning, the everyday use of the word. So when you see any proposed settlement, what you're thinking there is that we agree you'll get 5% of southern Belize, or you will not get anything, but we'll give you right of passage in our territorial waters. It's a specific settlement. We know what we're reaching. Going to referendum, the question is whether we should take it to the ICJ or not. That's not a proposed settlement. That is a method to reach a proposed settlement. And to me, that's where the controversy is. My opinion, based on my learning, and I'm sure opinions, everybody have them, and other attorneys may have a different opinion. But my opinion, having done constitutional law and looked at drafting and everything, we all learned that is that section, take it back, the proposed settlement. Once we go to the ICJ, there should be a referendum after the decision of the ICJ, so that by referendum, we accept that decision as a proposed settlement. So whatever the ICJ says is going to be the proposed settlement. But that then brings in the question, but we said we signed a binding treaty where we agreed that the decision will be final. And therefore, that's one of the reasons we're at court. So the question is, can the government bind us to this decision? And the answer to me would be no. First of all, there are several errors that the claimants are making and pointing out. One, the fact that they're saying that the treaty, they could not have entered the treaty because it's a separation of power issue. But it seems that that's not that the CJ is not biting the bait for that one. Because he's saying, yes, they can enter into a treaty. So the question will therefore be, to me, the bigger question is, after you made that treaty, did you make it part of your domestic legislation? Because treaties are international agreements, but you have to then enter it into your domestic legislation for it to be applicable. That didn't happen. As far as I know, that didn't happen. So that's a major issue. Some people will say, but why did they wait until this 11th hour to go to court? It's not the 11th hour. You have to understand. there was not have, the government could have been saying for decades that there will be a referendum. But until they did an act to effect that referendum, then you have a case, because you couldn't go and preempt that there would be a referendum and go to the court. The CJ would have sent you back and said it's premature.
Yeah.
So once the writ was issued, and the writ was issued, I think the 25th of February or 28th, the ending of February, the writ was issued. I know that the Prime Minister wrote. And
on the 28th. The Prime Minister wrote on January 28th.
And the writ was issued?
25th of February.
Okay. So 25th of February, we get this writ. When the writ is issued, then there's a case to go to the court.
Okay.
And even some of the issues that they're discussing right now, I believe they have to wait for the referendum to be held for the youth to then dispute it at court, because then some things are premature. So what is happening now is that there is a claim. The claimants brought a case before the court. They sought an injunction based on their claim, but the way that operates is that an injunction doesn't mean that they've won all their arguments, you know.
Absolutely.
It just means that the Chief Justice is saying on the face of it, you have a very serious issue to be tried. The whole issue of the writ, okay, that's the issue I see so far that the CJ said is a vibrant issue, a live and an arguable issue. They said that whole issue about the writ, okay, I'm not saying you're right or you're wrong, but on the face of it.
But let's pause everything.
It's arguable. And so we pause everything and we will argue this case. But since then, a lot has happened.
So I want to, before we, because I know we have a lot to dive into with the Referendum Act itself and what the CJ is saying and the difference between, because it's a crucial issue, what the letter from the Prime Minister says and what the writ of referendum says. But you kind of went by it very quickly, and I wanted to be clear. There were different reasons cited as to why, or that the claimants brought to the court. And so one of the first ones was the legality, or whether or not the foreign minister had the authority to sign on to the special agreement. From what you've seen in the Chief Justice's judgment, what is it saying?
To me, I believe that he's basically saying yes, he can sign.
Okay.
I think he can sign. The problem would not be that. Having signed, did you come and incorporate it into our local legislation? You could go, any foreign minister can be authorized to go and sign. And I was reading the legal opinion of Carrie Musa, Anthony Sylvester, and Dickie Bradley. And they cited the proper legislation and case law where, yes, any treaty you could go and sign, but when you come home, how did you put it as part of the local laws? For example, the best example is everybody know the extradition treaty. We entered into an extradition treaty with the United States, but that was not enough. We had to then incorporate it into the law, and so we have an extradition act. So this treaty should have been incorporated into the local legislation. And that would be one of the arguments for sure. But at this point, we can't preempt.
At this point, correct? They're only focusing on the validity of the writ itself,
validity of it,
not necessarily whether or not the foreign minister could have signed or what have you, and whether it was then brought into domestic effect.
No, but although it's not part of the case, it's one of the issues that will arise. Because remember, they went with that special agreement and they passed it through the Senate. It wasn't even debated at the National Assembly, passed through the Senate as the procedure would be. So what the argument is that then the foreign minister, in entering that agreement on his own, is acting and binding us to it, is acting as though there's no separation of power between the legislature and the executive, because he went there as the executive. So it could become very academic, but at the end of the day,
these matters will have to be discussed in court, argued in court.
Yes, and the problem is, while many people may have seen by reading it, because there's some lay persons who, when they read this stuff, had some of the arguments like, well, how they could do that, how they could do that. But you needed someone who wanted to go to court, someone who has local standing, who has standing. And any political party would have that standing because they represent people across the country. So it seems political now, but that is the job of the opposition. That's Her Majesty's Royal Opposition, and if they don't step in and do what they should, and they're one of the few entities that may have the resources to go to court.
And that's part of what they have stated as well, at least the legal counsel, Senator Amy Courtney, who was here, spoke of that the rights of his clients have been denied because they've not participated in the debate.
Right, and they are a member of the government. They're a member of the National Assembly. We like to think about the government as only the party in power, but the government includes the opposition. And therefore the litigants in it. And who else would have brought it? I could have brought a case on behalf of a Belizean who would have been displaced, but it's more powerful when you get an entity that represents a wide cross-section of society, especially being that this is a referendum on a national issue. So they are the right persons to bring it. But I don't believe that they came too late, because the writ of referendum had to be issued before. I think they filed their case by the 6th or the 8th of March, so that was just a couple days after the writ was issued.
Let's discuss the writ in itself in terms of the language and the way it's written, because the Chief Justice hasn't said that there is anything right or wrong with it. He's basically saying let's look at it carefully, and hence the reason for the injunction. Let's look at what we have in front of us, Audrey.
Okay, so we have the letter from the Prime Minister, and he says the referendum is for voters to decide whether or not to take the dispute arising from Guatemala's claim to Belize's land and insular territories and to the maritime areas pertaining to them to the International Court of Justice for final settlement. It is in accordance with the special agreement and its protocols, and the government of Belize chose the date of Wednesday, 10th April 2009 for the holding of the referendum. So if you notice what he's saying here, he's asking that the referendum be held based on a special agreement. Thus my argument that he would have had to have a resolution. He's not saying it's based on that section.
Is it typical that you don't cite the portion of the law? Because he doesn't cite which...
No, because he's not going by the section of the law, he's going based on a special agreement. And the Referendum Act, remember, gives you 4 points. So the Governor General then cites the section of the law where it says outright.
It's right here.
Right, so you see there where you could read that part, the back part.
The second page.
Okay. Actually, I'll read the entire thing just so that we could follow along. It says here, now therefore I, Colville N. Young, Knight Grand Cross of the Most Distinguished Order of St. Michael and St. George, member of the Most Excellent Order of the British Empire, Governor General, in exercise of the powers conferred upon me by Section 3 of the Referendum Act.
Stop so that I just say what Section 3 says. Section 3 says the Governor General shall within 30 days of the passing of the resolution by the National Assembly pursuant to Section 2(1)(a) of this Act, or of the receipt of a certificate from the Chief Elections Officer pursuant to Section 2(4) of this Act, verify that the petition has been duly signed. So A has to do when you use a resolution. B has to do with when you actually have the petition, which is what we try to do. And C, or of a request made to that effect by the Prime Minister in respect to the circumstances set out in subsection 2(1)(c) or D. So this is the law. Now you have to go back 2(1)(c) or D. And C, where any law provides for the holding of a referendum on a specific issue or on any proposed settlement with the Republic of Guatemala for resolving the Belize-Guatemala border dispute. Continue so that we...
It goes on to say, do hereby order that a referendum on the proposed settlement with the Republic of Guatemala for resolving the Belize-Guatemala border dispute shall be held in the whole of Belize, and hereby require that you cause a referendum on the said issue to be held according to the law on the 10th day of April 2019, and that you certify to the Chief Elections Officer the total number of ballot papers counted and the number of votes cast for and against the proposition in your division in accordance with Section 5 of the Referendum Act, no later than April 11th, 2019.
Right, and Section 5 just says that the Chief Election Officer or the Election and Boundaries Commission shall appoint returning officers. So if you notice...
It's like triggering the election process?
Yes, so this is how the law operates. The Prime Minister specifically asked for a referendum based on the special agreement. The Governor General did not say, I am issuing a writ based on the special agreement.
Yeah.
He's just saying, I'm issuing a writ based on my power in Section 3. And that gives you all the option. And in law, you have to be specific. Which one of your power under Section 3? The one where a resolution came to you, the one where a petition came to you, the one where the law requires that you have a referendum, or the one where you reach a proposed settlement. So I'm not going to decide the case, but I'm just showing logically what could possibly be wrong. Remember, the Chief Justice has not made a decision.
Yes.
Both parties are arguing. But from my experience with these things, it sometimes sounds so monotonous and redundant when you do law. But if I write you a document specifically asking for that, and you are the authority to ratify that or give that power or permission, then you have to specifically give me what I ask you for. And so the issue in limbo is, okay, the Prime Minister is asking one based on a special agreement. On what power is the Governor General giving a referendum? Because there's nothing in the Referendum Act that says based on a special agreement you can then seek a referendum.
But can you then explain, because the opening of the writ from the government does cite Section 2(1)(d) of the Referendum Act, which speaks of providing that a referendum shall be held on any proposed settlement with the Republic of Guatemala for resolving the Belize-Guatemala border dispute.
Okay, which then brings us to the other issue. Remember what I said, this proposed settlement means that there's already crafted out terms. Not that what we are doing going to the ICJ is a method to reach a settlement. So the difference would be if you're Guatemala and you're Belize and you negotiated and you already know we want the people to ratify that we're going to give them SARS 2.
Like when the proposals were presented,
so
there was to be a referendum.
Settlement. So there was then to be a referendum that we agreed to that settlement. But what we're doing, we don't even know what the claim will be from Guatemala. And we are asking the court that whatever the claim is, you tell us the decision, and that decision will be the settlement that we should accept. And it sounds semantic, but it's just what the law says. So then, in my view, once the court gives a decision, then there should be a referendum in which we ratify that. And then you'll say, but wait, we already said in the agreement that it's binding.
I was going to ask that. Can you do a referendum after the court has ruled? The ICJ's ruling is final and binding.
But that's what the law says. That's what the law says.
But would it have any effect?
Remember, they have not incorporated that agreement into domestic law. So now one person very cleverly asked me this weekend, okay, so that may be true. There may have been an error in their method or understanding, and maybe the court rules in favor of the claimant. But couldn't the government just overnight change the law to remedy their defect? And the answer is yes.
They've done that in the past.
They've done that in the past. I remember very well when we were dealing with the Audit and Finance Act, when the Prime Minister violated it and then changed the law and made it retroactive to make what he did legal. So now here we have this Referendum Act, specifically, and it's their words, because remember, the first Referendum Act was 1999. Then the government came in and they amended it in 2008, in which they included some of these provisions. And we haven't even gone to the threshold yet.
Yeah, well.
And then in 2011, they amended it again. And then in 2017, they amended it to change the threshold. So now, what is important about that? What is important about that is under the special agreement, at the time of signing it, it was clear that they were supposed to implement this, this idea based on your national law at the time. So remember, the procedure shall consist of these stages, and it was clear that the special agreement shall be done according to each party's domestic legislation, whatever process you had in your legislation at the time. And at the time, what we had, because it was an amendment by this government, was a 60%. So you had
a 60%. It was a requirement of 60% of the voters to participate in the referendum to make it a legitimate process.
Right.
Right.
And if 60% didn't come out, then it was a null and void or invalid referendum. So that was 30th July 2008.
Yeah, 2008.
And so what did they do then? And the first legislation did not have this provision. But at the time when this was debated, this amendment was debated at the National Assembly, Prime Minister Dean Barrow was knocking his chest and saying that he was ensuring people involvement, that the Referendum Act will have some teeth now, that the way it was before, people didn't really have a say. And then he made sure that because these issues would be national issues, that 60% of the voting populace had to come out. And then 2017, well, from 2015, 2016, the Guatemalans began clamoring and telling us that they don't like what we have in our national law. But we never told them we don't like what they have in their national law. They proceeded to their referendum based on their national law without any amendment. But we turned around in 2017 and amended and say, as that for the avoidance of doubt. Imagine like if we ever had any doubt. Well, I never had any doubt, and that matter was personal to me.
Wasn't that viewed as sort of an acquiescence to Guatemala?
Of course, because the special agreement was clear that it was your domestic law. Why did we change our domestic law to suit them? So the act was amended and says, for greater certainty, it is declared that the issue or matter submitted to a referendum shall be, meaning it must be decided by a simple majority of the votes cast. So if 1% of the voting population comes out, they carry the majority.
Which was what it was prior to 2008.
That's what it was.
A simple majority. We changed to a threshold of 60% participation and then changed it back to the simple majority.
So you could look at it politically, then that's mean the previous government was right how they did it. And then this government was tooting their horn and say that they would increase the standard and hold us at a higher level of accountability and ensure that there is proper participation. And then by 2017, they admit, well, we had it wrong. The previous government had it right. Is that what really happened? No.
But there was pressure. There was pressure for the referendum to be changed. I think you're right. And we saw the media reports from Guatemala, and they were saying they'd waste their money because Belize won't be able to get the 60%. But I want to go back to an issue.
Before you go back to that issue, please notice that what has happened with that special agreement, that every amendment that has been made to it on it has been by pressure by Guatemala. Not one of those changes Belize has asked for. They asked for the date to be changed instead of it being simultaneously, which has a psychological effect. Only 27% of their voting population came out, and it was like a 95% said yes, they want to go. And then in Belize, we've never asked for any change. They then pressured for us to change our numbers, our threshold, and we gave in again. We've never gone and said, well, we want Guatemala to change these terms. They've always been the one.
Or to establish the protocol. But
I
don't want to lose the opportunity to go back to the Referendum Act under 21D, which is what is cited in the current writ of referendum.
Yes, let's go to 21D then.
Because what I am understanding you to say, and you can correct me if I'm wrong, is that essentially that portion of the law could never be used to get a referendum or to conduct a referendum on going to the ICJ.
Well, I won't say it can never be used. I just think it will take 3 stages.
So it
would take 3 stages.
Settlement.
Right. It would take 3 stages, in my opinion. 1, you reach the agreement, because you have to go by agreement to go to the ICJ. You then have your referendum and your people say, yes, we want the ICJ to decide. And after the ICJ decides, then we will have to then say, yes, we agree to settlement. Or the government will go and change the legislation. And when they change the legislation, instead of saying proposed settlement, they can put proposed method of settlement. I'm not giving them ideas now, because knowing them, overnight, and that whatever body arrives at a proposed settlement, that we would then by agreeing to go to a referendum before that, we will ratify or we accept that that's the settlement
I'm trying to put this sequence in order. So the special agreement says that the people of Belize and Guatemala must approve the jurisdiction of the ICJ, which means
that's the first step.
We Belize and the people of Guatemala have already agreed in their referendum, say, okay, we want to give the rights essentially to the ICJ to work out this solution.
Yes.
So we have to have a mechanism in place to trigger that referendum for us to give the jurisdiction to the ICJ.
Right.
And my question is, Tool 1D, which speaks of a proposed settlement, can we use that? I mean, this is what was used, but it seems if you're talking about a proposed settlement,
I don't believe that's the section they should have used. I believe it should have been a section dealing with the resolution. Remember, nothing stops the government from taking anything to referendum. So my opinion is that they should have passed a resolution saying that we want,
which is A.
Right, we want to ratify not only this agreement, but we want this to be the method to reach a settlement. So that would have been here where the National Assembly passes a resolution declaring that a certain issue or matter is of sufficient national importance that it should be submitted to the electors for their view through a referendum. So the view would have been, do you want to go to the ICJ or not? Let's say people say, yes, we go to the ICJ. Remember now, but we also have a law that says that if you are going to reach a settlement, you have to have a referendum. So you either remove that or you amend that. But or say that that's no longer a requirement. So it means after the ICJ says, okay, I believe that Guatemala gets nothing, and this is how we reached our decision, or I believe Guatemala is entitled to the SAR-STUD, then you have to come back to the people per how the law is right now, because that is the settlement. That is the settlement.
So essentially,
that is the final resolution.
Essentially, you're looking at three things, correct? You have a referendum prior, you go to the ICJ, you come back and you have a referendum again.
But
because that is what must go to the referendum.
I know, but what is the merit of a referendum after ruling from the ICJ?
Because the law requires it. It's mandated.
I know, but can it be, I mean, if it's...
So you're asking me to solve an error the government made.
No, I know.
They should have seen that this was coming after them. They should have seen this was coming after them. They should have done the right thing. They have a lot of legal minds. What I'm saying is nothing new. I'm not the only attorney who read the law and saw that it had to be a settlement. And you would say, so then why didn't anyone challenge it then? It would be premature. In my case, I'm waiting. I'm waiting to see, because after that is done, then there will be a lot of legal challenges because it is violating the law. So and sometimes the best strategy is to keep quiet because you're reading and seeing what's happening.
So what we're going to do is take a very quick break, and when we come back, we'll continue the conversation with Audrey Matura as we talk more about the Referendum Act and understanding the case that's before the court at this time. Please stay tuned.
When someone you love becomes a memory, the memory becomes a treasure. Channel 5 introduces the Daily Obituaries. The Daily Obituaries will broadcast all death and funeral announcements and memorials to honor your loved one's life and memories. The Daily Obituaries airs on Channel 5 prior to the evening newscast, with subsequent repeats at 10 p.m. and 12 noon the following day. It will also be placed online on our social media platforms, all for a standard package fee. Celebrate their lives and memories with Channel 5's Daily Obituaries. Honor in life and reverence in death.
So glad.
We're back, and if you're just joining us, we are venturing into our second segment with attorney Audrey Matura. We are trying to make sense of what the Referendum Act dictates, and part of the challenge that is before the courts is understanding how and under what mechanisms the government can ensure that a referendum takes place and the people have their say. Audrey, before we went to the break, we were talking about when a referendum would be deemed necessary based on our laws. Yes. And so you were saying that based on 2(1)(d) of the Referendum Act, where it says that any proposed settlement must be taken to the people.
Yes.
You're saying that after an ICJ ruling, it would have to come back to the Belizean public.
For a second referendum.
For a decision, for a vote, yes or no. Yeah. But the special agreement outlines very specific terms that the ICJ's ruling is final and binding.
Exactly.
And we have agreed to that.
Yes, I agreed to that, but that doesn't mean it's not in violation with our law. So that is where the legal arguments are. I'm not saying that they couldn't enter the treaty. I'm not saying that once we agree and we incorporate it by whatever means as our law, that it can't be final and binding. That's what our government is saying to the world. It's going to be final and binding, but it then violates what what our law requires. Because at that point, we will know what the settlement is, and our law is saying any proposed settlement with the Republic of Guatemala. And as a matter of fact, in the Guatemalan Constitution, there is a Section 183, which then gives the president the final say whether or not to ratify the decision of the ICJ. So they're in a similar position as we are, you know. Different legal minds have read their constitution and are of the view that even when they enter into that agreement, their constitution, our constitution doesn't say it, but their constitution gives the president the final say, like I would say, like a veto power to call it. So that they also, after there's a ruling under the ICJ, have to go back to their legislature. That's in their constitution. Ours is not based on the constitution. Ours is based on a Referendum Act that we are saying any proposed settlement with the Republic of Guatemala.
But the special agreement, the treaty, which both nations have signed on to, outlines specifically what will happen with the ICJ ruling. So what you're saying, while I'm not saying it's not a probability, the special agreement in itself is already saying this is the way we will move forward.
And that is why there will be legal challenge. Because we're saying it's going against the act. And then the government would have to amend this legislation and make it retroactive, which is nothing new. So what I want you to understand, there's a contradiction in what the Referendum Act is asking for and what will happen once we go to the ICJ. This has nothing to do with whether you think we'll win or lose. This has to do simply with what our law says. Let me tell you, even in 2011, when the government amended the legislation, they did not remove that requirement.
Let me introduce another, because one of the things I wanted to be clear on is under what grounds, how will we get to the point in time where the people of Belize will have a say in this and whether or not we go to the ICJ. So the first was, you said, you know, you can go to the House and just declare that we want a referendum. That was 21A.
Yeah.
Now, one of the arguments we'd heard consistently before this court case even started was that you had to go to the House and debate this issue and get a 2/3 majority, because essentially what you're doing is allowing for a potential change
in the Constitution,
if the ICJ rules that there is any change in our boundaries, which are clearly defined in our Constitution.
Yeah.
I know that sounds confusing. It takes... I'm trying to find a simpler way to say it.
It's how the legal minds they work, and it makes a lot of sense. Our Constitution defines our borders. Whatever the ruling is of the ICJ, if it does not comply with that ruling, does not comply with what we already have, basically what they're saying, what is in your Constitution needs to be changed. And the argument is, can by that special agreement alone the Constitution be changed, or do we need to go back to the National Assembly and debate it? There are those of the view that we don't need to debate it, and there are those of the view that we need to debate it. So I don't have a right or wrong answer. These are the legal...
So there are two interpretations.
Yes. These are the legal challenges we'll have along the way. You know, this is not the only case you'll have. But you have to wait for certain events to happen. You can't preempt because they said it will happen, that it will happen. Remember, one of the decisions of the CJ was that not because the Prime Minister went and said certain things will be done, that that is final. You have to make the event happen. So we have to make these events happen for there to be a legal challenge. And that's what the Belizean people don't understand. I wrote an article saying, follow the money. There's money in this for many people, you know. And the legal minds will be the ones.
Let me ask a hypothetical question here, Audrey. So we go to referendum in the first round, in the days ahead.
Yeah.
And if we say yes to the ICJ, we go before the World Court and this matter is heard, and the decision is then final and binding.
Right.
We come back and we have a referendum again. Won't the outcome of that referendum be heavily based on what the decision of the ICJ is? Because if we have to give up anything, it would probably send people rushing to the polls to say, no, we don't accept that decision.
Yeah.
Or vice versa, if we receive a yes vote, sorry, not a yes, but if we receive a decision in our favor, then we'll also be rushing to say, okay, it is binding and this is the end
and
of
I
it.
think what they were trying to do was to bring finality with it, through the special agreement. But in so doing, there were certain gaps that I believe weren't covered. Like this should have been amended.
Domestic law?
No way. Our constitution is supreme.
Yeah.
No,
Yeah.
our constitution is supreme. That is why the argument being made by the claimants that, well, at least in the legal opinion, because I've not been to the court to hear all the arguments, and so far it's only over the injunction. But what they've made, the point they've made in their legal opinion, that is Kareem, Anthony and Dickey, is that, look, the Constitution is supreme. By us entering an agreement that is binding us already to something that may change our borders, then it's sort of unconstitutional. And I say sort of because you have to debate it. And so to me, the error is in process. It's an error in process. And with all the legal minds that the government have, they must have gone and crossed all their T's and dot their I's and see that there are all these potential arguments. I mean, it's clear cut. I mean, any layperson will see that that section says proposed settlement.
Yeah. And I want to move.
But let me say one thing more. This could have been, another way this could have been dealt with is that the government didn't have to have a referendum right now. The government could have used its own power to go to the ICJ. There's nothing that says, because this is for
this special agreement that they signed on to.
And that's why I keep saying they failed us. They're failed leaders. They vex when I say that, but I say hashtag failed. Because listen to me. Parliament could have gone and debate this. And then they have the majority would have said, let's go to the ICJ.
Yes.
The government could have gone to the ICJ.
And in fact, that's how most cases go to the ICJ, without the people deciding.
Right,
yes.
right. So they could have gone to the ICJ. But in that agreement, they would have said that whatever decision of the ICJ, then they will have a referendum. So they wouldn't have made it binding. They would have said based on our referendum. And Guatemala would have had something similar because their president still have the power to change it. Then that would have been a proposed settlement. Then there would have been the need for only one referendum, because the ICJ would have made a ruling, which then we the people would have accepted by referendum. But the other way they could have done it is remove this. They could have removed this totally from the law. You know, the government.
But couldn't it be argued then that if the government was to have proceeded with a motion to the ICJ, and then afterwards you have a referendum, and then the people don't accept what that decision is, then it would have been tantamount to a waste of time.
Yes, but it would have been how they reached the agreement. And that is why they should have seen all these possible roadblocks. And they could have moved this from the law. And after there's a decision of the ICJ, no need for a referendum. It's just simply right now, in my view, what is happening, what our domestic law says, and what it says is you have to have this
any proposed settlement. Yes,
and what the agreement says they're not meeting.
So what I'm hearing from you, and I think that if we talk about all the different alternatives that we could have gotten to the referendum, we will spend a lot of time. But I really want us to understand what the alternatives are at this point. And if you could shed some light as to what the potential outcomes can be in terms of how we would get to a referendum on April 10th. So there are two processes happening. One is before the Supreme Court and one is before the Court of Appeal.
Yes.
For more understanding, what's been communicated to us, they're asking the Supreme Court to change the order. Right?
The Court of Appeal.
Yes,
they're asking the Court of Appeal to change the injunction order of the Supreme Court.
Yes.
And basically, so this is what people need to understand. The case is at the Supreme Court.
Yes.
They have inherent jurisdiction to hear any matter.
Yes.
This is a matter that the claimants have brought, challenging the agreement, challenging the writ.
Yeah.
The substantive case has not been heard yet. But before, because the referendum day is upon us, they had to ask for an injunction to basically say, stop the referendum, hear our arguments. If we fail, let the referendum continue. But if we don't fail, there can be no referendum. When the Chief Justice deliberates on that, he has to look at what is the balance of convenience. is there a serious issue to be tried, and can damages or money compensation compensate you if you don't have this injunction? Clearly he found that, you know, the balance of convenience lies obviously for make we hear this matter because of what it entails. The serious issue to be tried for him was the writ, and clearly if you let the cow out of the pasture already, money can't undo what the problem is. So he gave an injunction, and he tried to have an expedited hearing, which would have been today. There should be a hearing before the Supreme Court.
Yes.
However, the other party was not satisfied with that decision. And so they moved the higher court to say, look, we want to appeal that decision made by the Chief Justice of the injunction. We want to appeal that. That is their right to do as well. So they went to the appellate court and quickly filed their documents. The appellate court gave them a deadline for yesterday, 6 o'clock, not yesterday, Saturday, 6 o'clock, to send in their legal submissions, and today it should be heard. Now, 2 cases on the same day. Well, the one that takes priority is the Court of Appeal. I really don't know what time each was slated for, but most of them are slated either for 9 o'clock or 10 o'clock. So they are before the Court of Appeal first. The Court of Appeal can either say, well, we accept the injunction as is and we will not change it, or they can say we accept it, we will vary it, or they can say we remove it totally.
Yes.
There are 3 possibilities.
So it's a challenge against the injunction, and the actual case before the Supreme Court that's taking place.
Right.
Now, I wanna get your thoughts.
But it doesn't end there.
Yeah.
If the Court of Appeal says we accept it, the government can then appeal higher to the Caribbean Court of Justice.
Yes.
Or if the Court of Appeal says we will vary it and allow there to be a referendum, and after the fact we will release the results,
certify the results thereafter.
Which nobody likes that idea, but the government would love that idea, because you get 2 bites of the cherry, I say.
It comes across as a bit shady or questionable.
But let's
so then the claimants can appeal, and if the Court of Appeal say outright we knock down the injunction, they can also appeal. So then the CCJ will hear the appeal, right? After that happens, that still remains the substantive case to be heard. But once the CCJ makes the final decision on the injunction, that's our highest court.
Yes.
We have to proceed from there.
In your opinion, can this matter get to the CCJ before Wednesday?
Yes, yes, the CCJ moves fast too, quickly. I think it can. If I was the claimant, I would have.
It appears to be a bit unrealistic, though.
No,
I mean,
the same way you thought it would have been unrealistic that the Court of Appeal would have acted so quickly. If I was a claimant, I would have had my appeal drafted already. You have to preempt. The reason injunctions, are the type of cases that they go fast, because they're emergencies, so they act quick on it.
Okay.
So
would it be seen as such? Would it be seen as such at the ICJ level, notwithstanding the fact that they would basically set their own schedule when they're prepared to listen to it? Despite the fact that it's of a national, the CCJ, sorry.
Okay.
Despite the fact that it's of a national importance to us?
No, I wouldn't say that's how they operate, that they would set it at their own level. They would look at the emergency and the deadline in it. Up to Wednesday morning, there can still be arguments over injunction.
There's a question asked about the urgency of it. Wouldn't they decide on, okay, perhaps this can in fact wait for it to be totally and thoroughly ventilated?
Well, the court would make a decision either way. The CCJ would make a decision either way. Either, we will make a ruling on the injunction, or the decision will be here, have it ventilated, and then proceed through the system. I mean, whichever way they have to make a decision.
Could you have circumvented the Court of Appeal and gone straight to the CCJ?
Yes, I heard that they even gave that option. But the government said no.
Why would it not make sense to just go to the final court?
It is strategic. I mean, I can't blame the attorneys for the government. They want to drag out the process because they need to kill time. Now it's like basketball. You see when they have the ball because they're down to seconds because you don't want the other party, right? They play the clock. I think that's what's happening.
So if we talk about, there's several options that you allowed us to understand. The Court of Appeal can say the injunction stands, and then you move up to, most likely, then the government would take the case to the CCJ. If there is a variation, a change in the injunction, allowing for the referendum to go through and not certify the results, or lifting the injunction and allowing the referendum to take place, most likely, the claimants will take the case to the CCJ. So this matter may end up at the CCJ.
Yeah.
I want to look specifically at the issue of the variation of the order, and we had that explained by, I think it was the Attorney General, as to what we do, which is you allow the referendum to take place, and under our laws, the end of an election or a referendum is the certification of the results by the Chief Elections Officer. So you go out, you vote, but there won't be this final step where Chief Elections Officer Josephine Tamai certifies that this is the yes
after the substantial matter has been.
So
when how does that work?
When will the ballots be counted?
Well, the process that's been outlined to us was that at each station there is going to be simultaneous counting taking place.
Right.
So I'm just trying to, I mean, my question literally is, how would that work?
So the proposal would be we go out and vote, they count the votes immediately after, and then somebody we trust will keep it secret all along.
Is it that you can know the
in 31 constituencies, it will remain secret?
It seems dubious, to say the least, that you would actually...
We would have known the results because the fact that in every polling station is being counted, those who are the people overseeing will know the results.
But then my question is...
So you will know the results before. It does, honestly...
You trust in 31 people?
Given the lack of confidence people have right now in the process, the optics of it would not seem fair.
But my question...
It would create even more controversy.
I understand that,
and it would create even more litigation. Oh my God! I personally don't like that idea.
But I hear what you're saying. But my question has more to do with the fact that so the counting, we're not sure whether it will take place before or after.
And who will secure the ballot boxes?
Yeah.
Is it a situation where if people know the results, they know the results, but there's not the official certification?
Okay, let me tell you.
When we get the unofficial count, for example, we know who win, but we have to wait until
it's certified.
And say, here's Chief Elections Officer saying this one won, that one lost.
Let me tell you why that's not a good idea. It's not a good idea because the government through cabinet made a statement, passed a decision that they will vote yes. It's not a good idea because the United Democratic Party, which is the person forming or the party forming the government, voted yes. So if they had not taken a position and nobody had taken a position, there would have been a sense of confidence. But no, the very party, the very government that should now manage and oversee this thing has already taken a biased position, and you're asking that same cat to mind the cheese. The optics of it is not right. It would have been different, Marlene, had it been done the way it was supposed to be done. No political party was to take a side. There would have been a truly educational campaign. No need for there to have been a resolution by any political party or cabinet as to their position so that there not be a counter. And then the appearances would have been that this is fair. But you can't expect that to work in a process where the very people who are looking after the process are the ones who already declared their bias.
Can you tell me if
the optics of it is totally unjust? That's why...
From my understanding, what seems to be the case, if the variation takes place, if the injunction is allowed to go through without the certification of the results, we have nothing in our laws to tell us what the process would be. Much like we experienced with this referendum, where a standalone referendum like this had never been held, so the mechanisms had to be changed based on the commission. So where would the boxes be? Who would watch them? I mean, these are very practical processes that will have to take place. But do we have anything in our laws that we would know what the process would be?
We don't, but the Referendum Act gives the minister the power to ask the Governor General to make regulations. And that's one of the complaints I was making, that because it's our first referendum of this nature. We had one in 2008, but it was attached to the ballot.
It was tied to an election.
Then we had my so-called people's referendum that had nothing to do with this process, right? So this is the first referendum, and it's on one of the most important issues. And we have not even passed regulations to answer some of these very things. Let me tell you how I would end it. Hashtag failed. They don't want to admit it. They failed us in negotiations. The same leaders, they failed us in how they went about deciding our special agreement. They didn't consult us. That came to us. They failed us in they didn't look at all the possible errors that could happen. Therefore, there's room for litigation. And they failed us because they're stubborn. I'm glad there's a pause, but I want you all to keep in mind, all of this could come to an end once the government calls a house sitting, change that law. Right now, the law requires that if there's going to be a referendum and there's the writ issued, you have to wait. It has to be within 30 days. And they could change all of that and set forthwith. They have the power. But of course, if they do that, what would be the confidence of the people for the government?
And if they're to follow the letter of the law, what's the timeline that we would look at? If they go to the House and issue the resolution?
Well, if we follow it as it is, I would say everything is within 30 days.
So that would be in the June date that has been put forward as well.
Yeah. But remember, they can also go to the House and change that law and say immediately it becomes a dictatorship, but they have the power and they have the majority.
And how does that impact the case?
It doesn't impact the case itself because this is more our domestic process, which I've questioned from day one. There's something flawed with the process and they're repairing it using their legislative power.
It doesn't impact the case. You're right in saying that, but then again you use the word optics.
The optics is important.
And it looks bad that you would move in such a heavy-handed manner.
You already conceded to Guatemala more than once in the special agreement. You allow them to go without you on a different date. You've changed the threshold to suit them already. I mean, why is it that some people start feeling like, why are you pushing it at all costs? When if that's what you really wanted, why didn't you read the law good and follow the process? Why, and why? And so it's a good time to just put it on hold, accept that you failed, which is hard to do because we're talking about huge egos here, and we go on. But even if we go on, trust me, there'll be other legal challenges because I've met people.
And that's what I was going to say. Even if everything, let's say, it goes to the CCJ, the injunction is lifted, and the referendum is held. Do you foresee, or would you imagine that there will be even more legal challenges brought to the results?
In two areas I could already foresee. I've had access to information where public officers are now keeping records of all the irregularities taking place, where they are being instructed to put people on the list, people who registered after the deadline, after the 12th of March. So that will bust out. That's one. Two, there are people who got back their card and the cards have wrong signature, wrong picture.
There's a lot of errors.
Too many errors. And could you imagine a person like that? So I am saying to everybody, if you get your card with errors, quickly take a picture of it before you return it. Because we don't know what will happen. When you go to the poll, if there's an error in your card already, maybe there's an error on the list. So we don't know. So, but you have to wait for these events to happen. For example, if I go and they don't make me vote, even though I have my receipt that I registered within the deadline, then I've been disenfranchised and I have the right to then go and challenge what has happened. And so the more people keep record of all the irregularities happening, the more the challenges will be.
And what if the diaspora vote?
They can't vote. They have not met the requirements, which is a whole different issue. Like, for example, my son is now in the diaspora. He is a student away. He's not away because he wants, but he couldn't come back and wait here 2 months to register. And so he has been displaced. So people like those who are abroad because either for studies or work, whatever, have been displaced. And I heard an interview where one of the government officials said, well, you could come and nobody may go check that they're there for 2 months. But then that's telling our people, let's continue the culture where we lie and we do what's improper. And that's not what we want to teach our children. Let's do things the right way.
Let's go back a bit, Audrey, to the issue of the errors on the voter's registration card. I was having a conversation yesterday and we were saying, look, there are 4 pieces of documents that perhaps validates your citizenship as a Belizean, right? You have your passport, you have your social security card, perhaps a driver's license, and a voter's registration.
And your birth certificate.
Your birth certificate, 5. 5. And so that when you look at the voter's registration card, one that is being issued recently, and your name appears a certain way on your passport, it appears on the card differently based on a mistake that they would have made, or your gender or the signature is totally different.
It's someone else's signature.
Yeah.
Does that show, or does that prove perhaps that this process is being rushed?
It is
that,
rushed.
That there are so many mistakes that are slipping through the cracks that people aren't picking up on?
It is rushed. In my opinion, two things. It is rushed, and then they appointed new people to go help. If you remember the news interview that I think the Prime Minister gave, where he said they would put $8 million into the re-registration process, and they would hire like 300 newbies. So some of these people that genuine mistakes, they're new, but some of them are strategically being placed there because I believe, that they are ensuring that their people that they already know that they control needs to be registered. So you won't find errors on those cards, but you'll find errors on the ones that you know for sure, or you're not so sure. That's my sinister view of it. Based, and I'm being honest, it's my sinister view because of the types of texts and messages I get. I mean, I can't speak about potential clients.
There's also a larger issue here that we don't have a final list that has been publicized.
Yeah.
We've been asking for it non-stop. We have literally...
There
is no actual voters list that we've gotten as the media to say how many people are going to participate. And this is a crucial issue because this re-registration process, they had an estimate, I believe, of 200,000. The last conversation we had, I'm making my numbers wrong, about 150, 160. That's how far they were, but we do not have a final voters list. Even up to now, where they may or may not be.
Who's participating or who won't be participating?
Or what's the turnout? But I want to go to, because we got to wrap it up now. So can I ask you one question, just as an activist, as an attorney, what are you paying the most keen attention to right now as to what the outcome? Arguments in the Supreme Court, or how this will go through the upper courts?
I am paying more keen attention to the reaction of the government because I know that they have it within them to go overnight and change the law to suit them. They've done it before and they will do it again. Second, I'm paying keen attention to the case itself, but knowing that there's a process and that there are different tiers of the court, I'm not too concerned. I will keep faith that the judges will be fair and that the issues will be argued on their merits. And I know for a fact that even if they force the referendum on the date that they want and before the case can be heard, that does not stop the legal challenges after. It makes it easier to have the legal challenges after. And
just let me get in there and ask you one more thing. I hear it very much, and I seem to be getting the impression that you do have an intention of posing a challenge later on in the future.
Well, I remember certain events have to happen. If certain events happen, I have my own idea of what I would challenge. Of course, I wouldn't go on my own. I would canvass some of my colleagues to come join me because it's all going to be pro bono. I mean, nobody's going to pay us. It's something for a national interest. But I want to say one final thing on that list, on the whole re-registration process. Remember, we were to have re-registration every 10 years. The PUP failed to do it because it suited them during election. The UDP made a stink about it. They got in power in 2008. They were to do it by 2010, and they did the exact same thing the PUP did, which was pass a law and put it off. Now, they had their last election using the old list because it benefited them. But now, it doesn't benefit them under the referendum. And so, 8 months before the date, you're rushing to register over how many people? 200,000? Does that make sense? Well, with 300 newbies? Think about it. What is the motive behind the way they've done things? The optics does not look good. And I'll just end with one saying. Justice must not only be done, it must be seen to be done. The right thing does not only need to be done, it must be seen to be done rightly.
Okay. Thank you so much for coming in and breaking down what is a very legal issue for us and our viewers. We're going to go ahead and take a break. When we come back, we'll be talking to representatives of the bus associations. So stay tuned.